Joinder of causes of action. By a joinder of actions, or more properly, a joinder of causes of action, it is meant the uniting of two or more demands or rights of action in one action, the statement of more than one cause of action in a declaration. It is the union of two or more civil causes of action, each of which could be made the basis of a separate suit in the same complaint, declaration, or petition. A plaintiff may, under certain circumstances, join several distinct demands, controversies, or rights of action in one declaration, complaint, or petition. A party is generally not required to join in one suit several distinct causes of action. The joinder of separate causes of action, where allowable, is permissive and not mandatory in the absence of a contrary statutory provision, even though the causes of action arose from the same factual setting and might, under applicable joinder rules, be joined. Modern statutes and rules governing joinders are intended to avoid a multiplicity of suits and to promote the efficient administration of justice wherever this may be done without prejudice to the rights of the litigants. To achieve these ends, they are liberally construed. The statutory intent behind the provisions on joinder of causes of action is to encourage joinder of actions which could reasonably be said to involve kindred rights and wrongs. Although the courts have not succeeded in giving a standard definition of the terms used or in developing a rule of universal application, the dominant idea is to permit joinder of causes of action, legal or equitable, where there is some substantial unity between them. While the rule allows a plaintiff to join as many separate claims as he may have, there should nevertheless be some unity in the problem presented and a common question of law and fact involved, subject always to the restriction thereon regarding jurisdiction, venue, and joinder of parties. Unlimited joinder is not authorized. Our rule on permissive joinder of causes of action, with a proviso subjecting it to the correlative rules on jurisdiction, venue, and joinder of parties, and requiring a conceptual unity in the problems presented, effectively disallows unlimited joinder. So what are the requirements for there to be a joinder of causes of action? A party may in one pleading assert, in the alternative or otherwise, as many causes of action as he may have against an opposing party, subject to the following conditions. First, the party joining the causes of action shall comply with the rules on joinder of parties. Second, the joinder shall not include special civil actions or actions governed by special rules. Third, where the causes of action are between the same parties but pertain to different venues or jurisdictions, the joinder may be allowed in the regional trial court, provided one of the causes of action falls within the jurisdiction of said court and the venue lies therein. And finally, where the claims in all the causes of action are principally for recovery of money, the aggregate amount claimed shall be the test of jurisdiction. While joinder of causes of action is largely left to the option of a party litigant, Section 5, Rule 2 of our present rules allows causes of action to be joined in one complaint, conditioned upon the following requisites. First, it will not violate the rules on jurisdiction, venue, and joinder of parties, and the causes of action arise out of the same contract, transaction, or relation between the parties, or are for demands for money, or are of the same nature and character. Okay, let's discuss the first condition in Section 5 of Rule 2. That is, the party joining the causes of action shall comply with the rules on joinder of parties. The joinder of causes of action is indeed allowed under Section 5, Rule 2, but if there are multiple parties, the joinder is made subject to the rules on joinder of parties under Section 6, Rule 3. Specifically, before causes of action and parties can be joined in a complaint involving multiple parties, the right to relief must arise out of the same transaction or series of transactions, and there must be a question of law or fact common to all the parties. It is well to remember that the joinder of causes of action may involve the same parties or different parties. If the joinder involves different parties or multiple parties, there must be a question of fact or of law common to both parties joined, arising out of the same transaction or series of transactions. So this is actually referring to the rule on joinder of parties. In other words, if there are multiple parties, in order for a joinder of causes of action is allowed, there must be compliance with the rule on joinder of parties. How about if there is only one plaintiff and then one defendant? Can there be joinder of causes of action? The answer is yes. Next question. Should there be compliance on the rule on joinder of parties, or in other words, should the causes of action arise from the same transaction? The answer is no. So if there is only one plaintiff and one defendant, let's say the plaintiff has a cause of action for specific performance, cause of action for damages, cause of action for another loan, and cause of action for another damages, then the sole plaintiff can join all of his or her causes of action against the defendant. There is no requirement that these causes of actions must arise from the same transaction or series of transactions. In other words, there is no requirement as to the compliance on the rule on joinder of parties when there is only one plaintiff and one defendant. Let's discuss the second condition for a valid joinder of causes of action. The joinder shall not include special civil actions or actions governed by special rules. Therefore, there shall be no joinder with the following actions: Rule 62 to 71, which covers special civil actions, summary procedure cases, small claims cases, writs of amparo, habeas data cases, environmental cases, writs of kalikasan, continuing mandamos, and other cases covered or governed by special rules. The third condition for a valid joinder of causes of action is that where the causes of action are between the same parties but pertain to different venues or jurisdictions, the joinder may be allowed in the regional trial court provided one of the causes of action falls within the jurisdiction of said court and the venue lies therein. In one case, the Supreme Court held that it is true that one of the causes of action of respondents pertains to the title, possession, and interest of each of the contending parties over the contested property, the assessed value of which falls within the jurisdiction of the MTC. However, a complete reading of the complaint would readily show that, based on the nature of the suit, the allegations therein, and the reliefs prayed for, the action is within the jurisdiction of the RTC. It is clear from the records that respondents' complaint was for declaration of nullity of documents, recovery of shares, partition, damages, and attorney's fees. Clearly, this is a case of joinder of causes of action which comprehends more than the issue of partition of or recovery of shares or interest over the real property in question, but includes an action for declaration of nullity of contracts and documents which is incapable of pecuniary estimation. Moreover, it is provided under Section 5C, Rule 2 of the Rules of Court that where the causes of action are between the same parties but pertain to different venues or jurisdictions, the joinder may be allowed in the RTC provided one of the causes of action falls within the jurisdiction of said court and the venue lies therein. Thus, since one of the causes of action is incapable of pecuniary estimation, the complaint clearly falls within the jurisdiction of the RTC. The last condition for a valid joinder of causes of action is that where the claims in all the causes of action are principally for recovery of money, the aggregate amount claimed shall be the test of jurisdiction. This provision presupposes that the different causes of action which are joined accrue in favor of the same plaintiff or plaintiffs and against the same defendant or defendants, and that no misjoinder of parties is involved. The issue of whether respondents' claims shall be lumped together is determined by this paragraph, paragraph D. This embodies the totality rule as exemplified by Section 33, paragraph 1 of BP 129, which states, among others, that where there are several claims or causes of action between the same or different parties embodied in the same complaint, the amount of the demand shall be the totality of the claims in all the causes of action, irrespective of whether the causes of action arose out of the same or different transactions. Again, what are the objectives for the rule on joinder of causes of action? The objectives of the rule or provision are to avoid a multiplicity of suits where the same parties and subject matter are to be dealt with by effecting in one action a complete determination of all matters in controversy and litigation between the parties involving one subject matter, and to expedite the disposition of litigation at minimum cost. The provision should be construed so as to avoid such multiplicity, where possible, without prejudice to the rights of the litigants. Being of a remedial nature, the provision should be liberally construed to the end that related controversies between the same parties may be adjudicated at one time, and it should be made effectual as far as practicable with the end in view of promoting the efficient administration of justice. What are the types of joinder of causes of action? There is alternative joinder and cumulative joinder. There is alternative joinder when the cause of action is against either one or the other defendant. One is not seeking relief from both but from either one. There is cumulative joinder when one is seeking relief for all of his causes of action. What happens when there is misjoinder of causes of action? Section 6, Rule 2 of the 1997 Rules of Civil Procedure provides, misjoinder of causes of action is not a ground for dismissal of an action. A misjoined cause of action may, on motion of a party or on the initiative of the court, be severed and proceeded with separately. Okay? So when is there misjoinder of causes of action? There is misjoinder of causes of action when the conditions for joinder under Section 5, Rule 2 are not met. So for example, when there is a joinder of an ordinary civil action and a special civil action, that is not allowed. So there is a misjoinder of causes of action. Again, a misjoined cause of action may be severed and proceeded with separately. How? On motion of a party or on the initiative of the court. Let us discuss the case of Ada versus Bailon, GR number 182435, August 13, 2012. The complaint filed by the petitioners with the RTC involves two separate, distinct, and independent actions: partition and rescission. The Supreme Court held that the actions of partition and rescission cannot be joined in a single action. While parties to an action may assert in one pleading in the alternative or otherwise as many causes of action as they may have against an opposing party, such joinder of causes of action is subject to the condition that the joinder shall not include special civil actions governed by special rules. There was a misjoinder of causes of action. The action for partition filed by the petitioners could not be joined with the action for the rescission of the said donation inter vivos in favor of another party. Lest it be overlooked, an action for partition is a special civil action governed by Rule 69 of the Rules of Court, while an action for rescission is an ordinary civil action governed by the ordinary rules of civil procedure. The variance in the procedure in the special civil action of partition and the ordinary civil action of rescission precludes their joinder in one complaint or their being tried in a single proceeding to avoid confusion in determining what rules shall govern the conduct of the proceedings, as well as in the determination of the presence of requisite elements of each particular cause of action. A misjoined cause of action, if not severed upon motion of a party or by the court sua sponte, may be adjudicated by the court together with the other causes of action. Misjoinder of causes of action is again not a ground for dismissal. Indeed, the courts have the power, acting upon the motion of a party to the case or sua sponte or on its own initiative, to order the severance of the misjoined cause of action to be proceeded with separately. However, if there is no objection to the improper joinder or the court did not motu proprio direct a severance, then there exists no bar in the simultaneous adjudication of all the erroneously joined causes of action. It should be emphasized that the foregoing rule only applies if the court trying the case has jurisdiction over all of the causes of action therein, notwithstanding the misjoinder of the same. If the court trying the case has no jurisdiction over a misjoined cause of action, then such misjoined cause of action has to be severed from the other causes of action, and if not so severed, any adjudication rendered by the court with respect to the same would be a nullity because it was done without jurisdiction.